not too long ago, the Court of Appeal, the Supreme Court did hold that for security reasons, tribunals were allowed to sit in Abuja. And so with this judgment, basically, the kernel of this judgment is the fact that the primaries, not that the primaries didn't hold, which are pre-election matters though, not that the primaries didn't hold, that he held in Abuja, and that same tribunal also, for security reasons, is sitting in Abuja. And so, even though the Supreme Court had heard that the tribunal can sit in Abuja, but, these are some of, it's quite unfortunate the way we hold on mechanically to interpretations of our laws, And so that is why, in looking at this, I think the place where the primary was conducted shouldn't have ordinarily been the business of the tribunal, because for me, these are technical issues, they are technicalities. And the question the tribunal, I expect the tribunal should to be looking at is the fact that the primaries was held in Abuja. Did this substantially affect, the outcome of the election, the primaries? And then also the outcome of the election that was conducted. But the tribunal did also say that the votes that were counted for PDP were a waste on the ground that the primaries that they conducted was not ought not to have been conducted in Abuja. For me, basically, I think the tribunal, my reason anyway, the tribunal went too far on that, because it's as if the tribunal had to look for any and everything, just an opportunity to sack, the governor. But we should have passed this area, in modern times. I expect the tribunal to look more into the election that was conducted. The election that was conducted in April. That is the business of the tribunal, and not what happened before the election.
Can I just ask you?
Even though some people have argued that what happened before the election also can form some part.
Yeah, since it's in the Electoral Act anyway.
You said what?
I mean, since it is in the Electoral Act, because in taking its decision, the tribunal cited Section 177 of the Electoral Act, saying that the PDP violated it.
Yeah, that's what I'm saying. What I am saying is that these are in most cases before now, these are ordinarily pre-election matters that are not matters stricto sensu before within the jurisdiction of the tribunal. These are matters that parties in the party will take up against the candidate at the Federal High Court, arguing that the candidate for the election ought not to have been nominated on the ground that elections were not held, in compliance with the provisions of the rule. But in this case, the tribunal was constituted to look into what transpired on the day of election, and if what transpired was, enough to have declared a winner.
Now, what we need to consider is that the tribunal, or indeed any court of law, does not need to look at issues of law that have not been raised. If the issue of holding elections in Abuja is contrary to the constitution of this country, or contrary to the constitution of the PDP, or contrary to the electoral act, any of the parties do not need to plead it. The tribunal can so move to plead issues of law, deal with it and dispatch it, because it will not help you anywhere. Take, for instance, if the law says that you have to file an election petition within 2 weeks, 14 days, and then you file it within, you now file your own 20 weeks, or 6 weeks after the days allowed. The parties don't need to plead it. once the tribunal discovers that, it can give judgment on its own. What I'm saying in effect is that if you violate the law, parties the court and the parties cannot consent to violate a law. Perhaps that is what informs the tribunal's judgment. I'm not speaking of all the judgment here because it's not convenient, but I'm just giving you the information that if you have violated the law, parties do not need to plead law. It is the court can, in its own suo motu, take it on and deal with it. Because on the long run, it will not help you because you are going to have problems with it. If you have violated the constitution, you have violated anything, parties cannot agree to commit those kind of things.
Because this is quite surprising, as some people have said, that look, if somebody did not actually plead something in court, why should the court just assume that, assume it to be so and then decide to just rule on it?
That is what I'm trying to explain to you. You should get what I'm saying. What I'm saying is that they are pleading that parties can make, they are pleading that they will need to make. But I'm saying that on the issues of law, if, for instance, parties do not plead that a court does not have jurisdiction, because if you go file the matter of land in a federal high court, for instance, the land in a state, in a federal high court, for instance, the court does not have jurisdiction. Even if you didn't, any party did not complain, the court in itself will stay on its own, and it has the power, so moto, inherent power to say, we don't have the jurisdiction to do this. That's what I'm saying. It's a similar thing that if the court finds that what you are trying to say, even if the other party didn't say so, that a law has been violated, the law is that the tribunal or the court has the right to raise it on its own and judge on it and give judgment on it.